This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
Contract law. There always is one question within the first 7, always one question, sometimes 2, which are based on contract law. There is always one question in the last 3, which is based on contract law. So between 20 and 30% of the exam is based on contract law. The first 7 questions are all knowledge-based. That is, what do you understand by the expression offer and acceptance, and distinguish the two. So they're very short lines. Maybe the first 7 questions are probably only 2 lines at most, 2 lines each. The last 3 questions are all scenario questions, and he'll set up maybe 10, 12, 15 lines of a little story, and you have to apply the law to the facts that he's given you within that. So there may be 3 people in partnership, and one of them has contributed money to the partnership but doesn't want to take an active part. And another one has decided that he wants to retire, but he didn't tell anyone that he was retiring. And the one who's been left, he's entered into contracts, and the partnership's now in difficulty, and you're asked to apply the law to determine to what extent these 3 people are liable. So you need to apply principles of partnership law to the scenario question. You need to apply the principles of contract law to question 8, which will be the contract law question. And the other question within those last 3, these scenario questions, will probably be a company law-based question. It will say somebody's invested in shares, he only had to pay part of the amount, and now the company wants more from him, so they've offered him a good deal on buying some additional shares. And you have to apply company law principles to that sort of scenario question. But there will certainly be one of the first 7. There will certainly be one of the last 3 based on contract law. And there could very well be 2 questions in the first 7 based on contract law. So it really is important. It's a big area. And that's what we're going to be doing now for the next day and nearly a quarter. Contract law. Contract is an agreement. It's worthwhile remembering this definition, because in any contract law question, when you're starting your answer, you can say the area being asked is the area of contract law, and a contract is an agreement supported by consideration, made with intention to create legal relations. And it's important that that definition is fully satisfied, because if it's not fully satisfied, it's not a valid, binding, enforceable contract. It's just an understanding between 2 people. But if it's not supported by consideration, or even if it is, if it's not made with intention, then it's not a contract, and therefore contract law will not apply. If it's not a genuine agreement, contract law will not apply. The agreement itself is made up of 2 elements. I make an offer, and you accept that offer. Then we have a contract. But there's nothing in writing, and there doesn't need to be. We do not need to have formal, written proof of our agreement. I can make an offer to sell you this revision kit. I'll offer to sell it to you for $2. And if you accept, then we have a contract. Nothing written down, doesn't need to be. Ideally, it will be written down, because that eliminates argument. If it's written down, it will eliminate dispute to an extent. But it's equally valid if it's just an oral contract. It doesn't have to be written. But we can even have a situation where we're in contract simply by the way we conduct ourselves. It's called a contract by conduct, or an agreement by conduct. And if I conduct myself in a way that looks like it's an offer, and if you conduct yourself in a way that looks like an acceptance, then the conduct that we are each carrying out would be possibly taken by the court to be an agreement and therefore potentially a contract. So not only do we not need it in writing, we don't even need words. You can enter into an agreement simply by the way you conduct yourself. No stamps, no notaries, no registration with the registrar of contracts. No. Difficult to prove. A contract by conduct, difficult to prove. Even an oral contract is more difficult to prove than a written contract. But they're still valid contracts. When you get on the tram, you stand at your normal tram stop, the tram stops and you get on. Do you actually say anything to the tram driver? Do you actually say, good morning, I'd like to enter into a contract with you. Here's my 70 pence. Can I have a ticket which will take me to the National Theatre? Is that what you say when you get in on a tram? Or do you just get on the tram and sometimes flash your card against the if you remember, to show your ticket? Or even if you don't have a ticket, do you actually say anything to the driver, or do you just put your 70 pence down on the tray and he gives you a 70 pence ticket? Don't say anything. But it's a contract by conduct. By putting my 70 pence down, I have indicated that I want to use his tram service to get me to somewhere on the tram system, and him, by taking my money and giving me a ticket, is accepting my offer. No words spoken. Invitations, offers and acceptances. This is quite a common topic within F4. I said that an agreement is made when we have an offer plus acceptance. That equals a contract. Equals an agreement. It doesn't necessarily equal a contract. That equals an agreement. So there are two people, or there are two steps involved. I make an offer, you accept that offer. We have an agreement. But it's potentially the case that instead of me offering to sell this pencil to you, I will sell this pencil to you for $4. I'm offering to sell this pencil to you for $4. Then you, by saying, yes, okay, I accept, it's just the two of us involved. I've made the offer, Sandra has accepted the offer. But what if I say, I have a pencil available for sale here, and it's got some writing on it. I've got a pencil available, and I'm prepared to sell it. Might you be interested? So I'm inviting you to make offers to me. It's not me offering to sell it. I'm inviting offers to be made to me. And so now I become the person, they're called the offeree. You're making the offer, so you are the offeror. And you're making the offer to me. I am the offeree. And it's up to me now to agree to your offer. So the responsibility is turned over. And instead of having this two-stage method, what we may alternatively have is an invitation by me to sell a pencil. It's called an invitation to treat. And that will lead to you making me an offer and me accepting that offer. And that will then give us our agreement. And it's important that you are able to distinguish an invitation to treat from an offer. Because an invitation to treat is not capable of acceptance. An invitation to treat is asking you to make me an offer and then I will accept. I can't invite and you say, yes, okay. It's an important distinction, and you really must be very, very clear on the fact that this is a three-stage element. I will invite, you make an offer, I accept your offer. And a number of cases have arisen in the past, and you've got them here listed out. Goods in a supermarket. When you go to Moll's supermarket, and there's a packet of cornflakes on the shelves there, is this an offer? And you're taking it by taking this packet of cornflakes, you're accepting the offer, and then we're in a contract? No. It's an invitation. It's saying, oh, look, we've got all these cornflakes and they're available for sale. Would you like to buy some? Would you like to make me an offer? So you taking the cornflakes to the checkout is you making an offer. And it's now up to the checkout person to accept your offer. Goods in a supermarket. Goods on display. And there's a case there. It's called Boots. If you look down the next 4 lines, we've got boots, bells, birds and balls. So they should be easy enough to remember. This case is a case called Boots. Boots is a big chain of chemist pharmacy shops. And the case is actually called Pharmaceutical Society of Great Britain. And Boots Cash Chemists. ACCA. And there is a law, in fact, there's a law that says that poison shall not be offered for sale unless it's under the supervision of a qualified pharmacist. And Boots Cash Chemists had some poisons on their shelves. And they were found out, the Pharmaceutical Society saw that they had these poisons on the shelf and took them to court and said, you're breaking the law here. So it went to court and they defended themselves and said, these poisons on our shelves are not being offered for sale. This is not an offer. This is an invitation, inviting other people to take the poison off the shelf and go to the checkout counter and say, I want to buy this poison because I no longer like my husband. And that they were making the offer to the chemist. And the chemist was able to show that whenever poisons appeared at the cash desk by prospective murderesses, whenever poisons appeared there, they were able to show that there was always a qualified pharmacist within 10 meters. And that if the poison was there, then they would say, Jennifer, can you come over and authorize the sale of this poison? So they shall not be offered for sale, except under the supervision of a qualified pharmacist. But although we had the qualified pharmacist there, that doesn't really count. It wasn't an offer. They were not being offered for sale. They were an invitation, inviting people to make an offer. And that distinction is really quite vital. Isn't it? Yes, Mike, it is. Goods in a shop window are invitations. Goods in a shop window. This is a Bell's case. This case is a case called Fisher and Bell. And the subject matter of this case is an offensive weapon. It's called a flick knife. A flick knife. Make sure you write that down clearly. I haven't done. Make sure you write it very clearly. It's known as the flick knife case. You should be able to remember because of the head of your national airline. If you remember or think about knifing him, then that should help you remember the flick knife case. A flick knife is a knife which is just an ordinary, just looks like a handle, but if you push a button, the blade flicks out, and it is offensive. So you can keep it in your pocket or your handbag. It's very safe until somebody comes along and attacks you, or until your parents say, no, you can't borrow any money, and then out comes your flick knife, flick it up, and get rid of them. So that's your flick knife, and it's about a shop in Glasgow. And the piece of legislation called the Offensive Weapons Legislation, which prevents the sale or offering for sale of offensive weapons. And there's a flick knife in the shop in Glasgow, and a man comes along and he sees the flick knife and he goes into the shop and says, I want to buy a flick knife. Now, the policeman, actually, was a policeman, came and saw that this was available for sale. And he went in and said, this is against the offensive weapons legislation. You're offering for sale an offensive weapon, and therefore we're going to prosecute you. And he went to court and he defended it and said, it's not offered for sale, it's an invitation. It's putting something in the shop window to attract Glaswegians, people from Glasgow, to attract them and say, oh, look, a new flick knife, let's go in there and see if we can buy it. And they would go in and say, can we buy the flick knife? And the shopkeeper would say, no, it's only an invitation, it's not an offer. So it's not capable of being accepted. You can't come in and accept it, it's not an offer. It's just an invitation to get you into the shop. But now you're here, I've got all sorts of other weapons that you can buy. So it's the distinction between offer and invitation is crucial. Goods in a shop window are invitations. They're not offers. The third one, adverts. These are normally invitations. It's the bird case. There is a bird. Do you know the whiskey called Famous Grouse? Do you know the whiskey called Famous? Do you know? No? You do, you know it, all right. And it's got a picture on it of a sizable bird. It's about the size of a hen, a big hen. And it's called a game bird because people go and shoot them for sport. Well, there's another type of bird called a partridge. A partridge. I'll write it down for you. You can remember it because the top of a row of hills, these are the ridge. This is the ridge of the hill. And if I look at that little bit there, that's a partridge. Okay, so the plaintiff in this case is a man called Partridge. The plaintiff and the defendant is, you'll not remember this, Crittenden. Partridge and Crittenden. So you can see instantly, because a partridge is a type of bird, why this is called the bird's case, or why I call it the bird's case. But even more so, the subject matter of this case was birds. And the particular type of bird, although you'd not probably be expected ever to know it, a particular species of bird is something called a bramble finch, or sometimes it's called a brambling. And there's no way in 2 months' time in the F4 exam you're going to be sitting there thinking, what was that type of bird? Was it a bullfinch? It doesn't matter. So long as you remember partridge, because that's clear. In the partridge case, the subject matter was birds, and the principle of law is that an advert is normally an invitation. It's not an offer. So if somebody advertises something, you can't go along and say, I accept and we're in a contract. The particular bit here was that this shop owner, let me go back. Birds in England, UK, are typically, they're protected by law. We can't have people shooting them and netting them and killing them, unless they're hens and you want chicken for dinner. So birds are protected by law. There's only 6 species of birds which are not protected by law. And even then, one of them is not protected just in a particular area of southeast England. So the bullfinch is protected everywhere throughout the UK except the bottom right-hand corner. Everywhere else it's protected. So birds are protected. And bramblefinches are not within this category of 6 types of bird which are not protected. They are protected. And you're not allowed to offer for sale wild animals, wild birds. There was another case involving something called the great crested newt, which is like a reptile, like a lizard, but it swims in the water. And you're not allowed to sell these things or offer them for sale. And this man who owned a pet shop advertised in a magazine, and he said, offered for sale. The advert read, offered for sale. Bramblefinch chicks, I'm not going to write all that out, cocks and hens, that's males and females, bramble-finch chicks, and you put a price in there. Offered for sale, bramble-finch chicks, cocks and hens, £2. And the Royal Society for the Protection of Birds came along and said, you're not allowed to offer wild birds like this, offered for sale. He went to court and he said, it's not an offer. It's not an offer. It's an invitation. And therefore I'm not guilty of the legislation. I'm not guilty of offering for sale protected birds. And the court looked at the abbot and said, it says offered for sale. But adverts are invitations, even though it says offered for sale. It's not an offer. It's not an offer. It's an advert, and adverts are invitations. Just occasionally, an advert may be seen to be an offer. The general adverts are invitations, but very, very occasionally an advert is an offer. It comes about, it's the Balls case, it comes about as a case called Carlil and Carbolic Smoke Ball. This is in your cars list. Carlil and Carbolic Smoke Ball. Mrs. Carlil and the Carbolic Smoke Ball Company. We're going back a number of years. The Carbolic Smoke Ball Company had got a patent medicine. And the idea of this patent medicine was that if you took a course of treatment of this medicine, these carbolic smoke balls, if you took a course of treatment of them, then that would improve your singing voice, it would stop you snoring, and it would prevent you from catching influenza. And Mrs. Carlil said, yeah, she'd like to improve her singing voice and stop snoring and not catch influenza. And the advert went on and said, to show how confident we are of our product, we will pay anyone £100 if they prove us wrong. And to show even more confidence, we're going to put £1,000 into this particular bank account, and the money is there, and you're never going to get it because our product is so good. Mrs. Carlil took the treatment, and she took these smoke balls, and she breathed them in. And after the 28-day course of treatment, after about 27 days, she started sneezing. In 28 days, she's got mucus coming out of her nose. On 29th day, she's in bed, really ill, running a major temperature, sneezing, hot and cold sweats. And she'd been taking these smoke balls religiously, and yet they'd not prevented her from catching influenza. So she sued. And the smoke ball company defended themselves, and they raised 5 defenses as follows. They said, if it is an offer, it's an advert, and adverts are not offers, adverts are invitations. But if the court thinks it's an offer, then this is an offer to the world at large. And that's not possible. You can't make an offer so that everybody all over everywhere is able to accept your offer. I can make an offer to Sandra. I can make an offer to all of you. I can make an offer to all the people who live in your country. But I can't make an offer to the world at large. That's not possible. An individual or a group of individuals, the size of your population, but not to the whole of Europe. Not to the whole of Europe and America and Asia and Africa and Australia. They can't do that. So that was their first defense. The second defense was that there was no intention to create legal relations. And remember the definition of a contract. The definition of a contract is that it's an agreement supported by consideration made with intention to create legal relations. And they never intended to create legal. They were just sales gimmicking their product. Our product is really good, it will stop you snoring. So it was merely advertising gimmickry. The third one was that the offer, if it is to be taken as an offer, the offer is too vague. It's too uncertain, really, the time period within which the offer should have been accepted. It's too vague. I mean, they didn't say if you catch influenza within 6 months of taking it. So are they really offering this product and saying it will prevent you from snoring for the rest of your life? So it's too vague about the time period. There's no certainty within the if it's an offer, within the offer. Fourthly, you know, when I'd made you an offer, I'm expecting you to communicate with me and say, yes, okay, Mike, I accept. And Mrs. Carlyle never did. Ask me, Julia, ask me. We have an expression in England called the blind leading the blind. What was your question?
I can see last word.
The last word? Period. Mrs. Carlyle never contacted the company, and she didn't say, look, I've read your adverts and I've just bought some smoke balls and I'm going to go home and start treating them, and if I catch influenza or if my snoring continues, then I shall be in touch with you. She never said that. Didn't say anything. There was no communication with the company. But when I make you an offer, I'll sell you my car. I'll sell you my car for £400. It's not just sitting there thinking to yourself, yes, okay, I accept that. You've got to tell me. And if you don't tell me, I don't know that I'm in a contract. So the offeror, when he makes the offer to the offeree, in order that we have the agreement, offer and acceptance, you must communicate your acceptance to me. You must tell me that you're accepting my offer. And Mrs. Carlyle never did. There's no communication of acceptance. And if she doesn't tell them, how can they know? And finally, the fifth defense that they raised was that there was no consideration moving from Mrs. Carlyle.